so that you will know that you're not just a number to me. And it's easier for me to remember faces and names as opposed to SID numbers. I had one client though, his SID numbers were 3 digits, so that was easy to remember. And you know what that means if your SID number only has 3 numbers.
Time ago.
Oh yeah, when I would go see him at the jail, the people at the jail, no, Stephanie. I'm like, no, those are his numbers. And then they're like, oh my God.
Right off the bat, it's clear that someone's run out of patience. The judge isn't here for excuses, and the energy shifts instantly. You can feel the tension building, setting the stage for what's likely to be a rough ride ahead. It also hits on something deeper. Have you ever had to apologize for someone else's mess? If you've been there, you know exactly how heavy that moment feels.
From, I think, 1960. So that is why he had the 3-digit number. Oh, yeah? Oh, wow. All right. So, Mr. Bernal, do you want a jury trial or a bench trial? What do you want?
Judge, he wants me attorney.
Oh, why?
I don't think she's surrendering my best interest. I'd like to hire her.
All right. So here's the thing. Let me explain something to you.
Rightly said.
Sometimes, and it's okay if you want to hire an attorney, that's fine. Sometimes people think an attorney is not working in their best interest because that attorney is not giving them what they want.
Right.
Sometimes people want a dismissal and the attorney says, well, I talked to the state. State says they're not dismissing it. They can't force the state to dismiss a case. If you want a dismissal and the state says, no, we have enough evidence, we're not.
This is a major turning point. The choice between a jury trial and a bench trial. Put simply, do you want a group of everyday people deciding your fate or just a judge alone? A jury can be unpredictable, influenced by emotion or perception, while a judge is often brutally direct and rooted strictly in the law. It's a high-stakes decision. Which would you choose?
Then your choice is, hey, either you accept that they're not going to dismiss it, enter into a plea bargain agreement, or either you go to a jury trial or a bench trial. But your attorney can't force the state to give you what you want. That's not really how it works. The way negotiations work is they'll go to the state. Maybe your attorney will tell the state, hey, I see some bad issues with your case. This is what you're going to have a problem proving. And then the state will be like, oh, I didn't view that. These prosecutors will do that. I don't know what other prosecutors are doing, but they're saying like, oh, I didn't consider that. Let me look into that. And then they'll probably look into it. And if everybody agrees on what they're seeing or what the issues is, they may say, you know what, we are going to dismiss it. But you're charged with the burglary of a building.
Right.
So burglary of the building cases, they're very simple.
Let's pause here.
This is a real glimpse into how plea negotiations actually unfold. The judge just delivered a quiet masterclass, reminding everyone that it's not about personal wants or emotions, but strictly about the evidence. If there's no smoking gun, there's no dismissal. It's that straightforward.
In terms of what needs to be proved. So if your attorney is not giving you what you want, which may be a dismissal, that doesn't mean that they're not working in your best interest. It just means that the state said they're not going to dismiss it. State, on Rafael Bernal, are you all going to dismiss this case?
We will not be, Judge.
So is there anything that the defense can do to make you dismiss this? I guess other than that you're on video at the picnic with the pastor or something. You know, I said there's nothing that she can present to them that is going to make them want to dismiss your case. They're saying they're not going to dismiss it. Is that correct?
That is true, Judge.
Is there any information that the state can bring you?
That defense could bring us?
Yeah, I'm sorry, that the defense could bring you to have you dismiss this case?
There is not, Judge.
So they're not going to dismiss it.
Okay, everything that you said prior to this about how she's not doing her job.
No,
Let's explain.
I'm not saying she's not doing her job. What I'm telling you is it appears that you, and I'm using it as a hypothetical, you want a dismissal. The state is saying they're not going to dismiss your case.
But she hasn't also given me the proof of why I don't have a case for dismissal. She's never given me. I need to look at the proof to see what proof they have to convict me.
All right, so let's do this. Could you go over the paperwork with him again?
Yes.
All right, and State, could you make sure that she has your file so that she can show him police reports and everything?
Certainly, Judge.
On the record, respectfully, Judge, I have shown him all of the documents that we have in the state's file. He's looked at the state's application.
Oh, no, here's the thing.
Yeah.
Sometimes,
We'll do it again.
yeah, sometimes people go to the jail and maybe they forget certain things. I don't know.
Now this is interesting.
Now, this is where things get interesting. The judge is showing an unusual level of patience, even going so far as to suggest the defendant might have simply forgotten some details. That kind of grace is rare in a courtroom, but it raises a compelling question. Is this genuine forgetfulness or a calculated strategy?
And she's going to explain to you, according to the penal code, what burglary of a building is. All right? Part of it is going inside a building without consent. So that's part of it, right? No. Here's the thing. That's part of it. So she's going to go over that with you and show you what's in the police report, okay? And then we'll come back. But what I want you to know is when you're sitting over there, the state is saying they are not dismissing the case and she can't force them to dismiss it.
I understand.
Okay.
Fully.
Okay. All right. All right. Thank you. Just have a seat.
May I make sure, just on the record, he has made very clear that he does not want me representing him, that he wanted to retain an attorney. Do you still want me to
Oh, yes.
Okay.
I mean, do you have an attorney here today?
No.
All right. So yes, you're his attorney.
Okay.
All right. Thank you.
So I just don't want to complain. Yeah, she's ordered.
No, she is going to show you
Right.
all of the documents that the state has against you.
Okay.
And then once she's shown you that and you've read it, just come back before me, okay?
Okay.
All right, thank you.
Thank you, Judge.
Thank you, counsel. It's about the concurrent.
Thank you. Yes, I mean,
Raphael Bernal. And Rick, if you can let me know which one that is, and they can pull the file and I'll make sure I write it on there.
okay. I can let you know right now. Or-
Okay. Let me grab a sticky note. If you want to write it from here,
Yes, sure.
then I'll take care of it.
Thank you, Yana.
You're welcome. All right, Raphael Bernal.
Yeah.
Oh, Mr. Bernal.
No.
Hi. So you want a jury trial, is that correct?
Yeah, I was off for 8 months.
No. Here's my question. Legally, I'm not supposed to hear what plea negotiations y'all have made because legally those are supposed to be confidential.
Right.
So I'm going to wash my brain of what you just said. So my only question for you is, are you reaching an agreement with the state or do you want a jury trial? That's either yes, I want a jury trial, or no, I don't want a jury trial. All right, so here's the thing. We've been here on this train before. So the train stops.
Here comes the storm. The judge isn't holding back, firmly pushing defendant into a harsh reality check. If you don't have the money, you can't just demand a new lawyer. It's a tough truth that exposes a deeper issue. Justice isn't always equal when financial resources come into play. It's a sobering moment that forces us to consider the gap between legal rights and real-world access.
I will give you a jury trial. So do you
I'm
want,
a lawyer.
well, do you have money for an attorney?
No.
All right, then that's where we are. This is your attorney.
No.
All right, so you're going to represent yourself?
No, you can hire me another attorney.
No.
Judge, respectfully, I'm sorry. Can I speak to my client for a second?
Yes.
Mr. Now, can you step over, please? Step over, please.
Nothing here. They don't send you to prison just because you don't have money. I don't have money. I need another attorney.
All right, let me
I need
stop.
another attorney.
Oh, no. Just 1 second. Let me ask you this.
Yes, Judge.
Are you appointed or retained?
Appointed.
All right, you're appointed. So what that means is that the government, the state of Texas, the taxpayers, because you can't afford an attorney, had this attorney appointed to represent you.
Right.
So this is your attorney. If you want another,
Mr.
if you
Brown.
want another attorney,
Yes.
then you need to hire one.
How?
I have no idea. All right.
You don't have no idea.
Judge, may I present the case?
I'm telling you
May I go
now.
forward and try to represent him? He has,
No, you
I think he's
appoint me
upset.
another lawyer.
I think he's upset, and it's possible that I mentioned before, he's very knowledgeable. He knows a lot of the law. It's old law. I've tried to update him on some of the laws, on some of the charges that he has had in the past, and the charge we're talking about today, which is burglary of the building. I
It's a
explained the
repeat.
difference.
That
Difference.
time I was here before.
So we're not gonna-
No, I need to explain.
So what I
It
would
was
like
the
to do right
same
now,
thing, burglary of a building, and it was dismissed. And now it's a repeater.
Let me ask you something, Mr. Bernal.
Yes.
You're Raphael Bernal?
Yeah.
What do you want to say?
I just said it.
No, what do you want to say? We're here to listen because you keep interrupting your counsel. So nobody's going to say anything. I'm going to let you speak. What is it that you want me to know?
What did you not hear?
I didn't hear any of it.
Why not? Everybody heard.
No, they did not.
You didn't hear it.
No, they said they did not. So what is it you hear?
Mr. Bernal. Judge, can we get a second, please? I'm sorry.
No, that's okay. Sometimes, counsel, I understand where you are, but sometimes when people don't get their way, they behave childlike, which is fine. So this is what's going
I'm
to
64 years
Counsel-
old. I'm older than you.
counsel. You assume that. Counsel,
Where
this
did I assume that?
counsel.
Sorry.
This is what's going to end up happening. You're going to go to jury trial. You will be his attorney.
A woeful courtroom meltdown unfolds, one of those emotional outbursts that sticks with everyone in the room, and not for the right reasons. But beneath the surface, there's something more going on. Is this an explosion of frustration or a moment of raw fear? Whatever it is, the case has clearly shifted. It's no longer just about burglary. It's unraveling into something far more emotional and complex.
If he doesn't want to take your advice or listen to you, then he doesn't take your advice or listen to you. But people need to realize that when you're appointed, people need to realize that when you're
That's bullshit.
when you're appointed an
She's
attorney,
working against me.
Mhm.
You're working against me. The district attorney is working against me. And you're not listening.
So the bottom case number is one that only shows up as being sentenced to, the top two need to be concurrent with it.
thank you.
I'm sorry about that.
Hey, here's the thing. You know what I always say?
It's one of those days.
No, it's mine. But
Well, even for me too. My
there's a
short
song by Monica, just one of them days. But here's my whole thing. Everybody needs to stop apologizing for other people's action. That's a grown man. There's no need for you to apologize for him.
It offends us to see that.
Sorry,
It
Judge.
does.
So
Yeah.
bad.
Don't feel bad. That's not you.